In today's episode, we are going to be talking about what are the different types of deeds in real estate. We're going to be talking about voluntary deeds, involuntary deeds. We're going to be going over grant deeds, quick claim deed, performance deed, deed in lieu of foreclosure, transfer upon death deed. We'll go over sheriff's deed, tax deed, gift deed. This is an episode that you want to watch until the end. To help us out, we have Jennifer Felten. She's a repeat guest. She is the owner of ReLaw, and she's going to be educating us just how different deeds are used. Welcome back.
Hi, Jose. Nice to see you.
Yeah, same here. So let's just start off like, what is a real estate deed? And then we'll jump into the difference between a voluntary and an involuntary deed.
Yep. So a deed is a document used to transfer title. So it is a contract, right? The person signing it is attesting that they own something and that they're giving their rights in it, right? It's done for real estate to a different party, right? So that's what it does. It is put in the public record, so it's recorded, which allows for it to put the world on notice of who the owners are for a property. So if I'm going to buy a property, I want to make sure that the person I'm buying it from is the owner, and that person would have gotten it via a deed from someone else, right? So that is the process of buying and selling real estate. That deed is the title and how we show who owns what.
So basically, is another word for a deed a title of a property, almost like a pink slip for a car?
It's kind of like that. It's not done through, like, a pink slip is done through a governmental regulated process. Deeds are done through the recorder's office, and they're not regulated, right? So they won't have an ID number. Like a house doesn't really have an ID number, though it has a bunch of numbers that are associated with it. It'll have a legal description. It'll have a property address. It'll have an assessor's parcel number because we want to tax it, right? But so it is, that document is showing it's your title. It is who owns the property.
Got it. I love it. Okay. So what is a voluntary deed versus an involuntary deed?
Yeah. So it goes to who is signing the deed and what authority they have. So a voluntary deed is, I decide to sell my property. I go hire you to enter into a transaction. We find a buyer. I will sign a deed, right? Authorizing that transfer, and that is voluntary. I am voluntarily choosing to transfer based upon consideration. An involuntary deed is, I allowed someone to get rights relative to my property. Different types of involuntary deeds are done through foreclosure, right? So if I borrow money, right? So say you lend me $1 million to buy a house, and I don't pay you back the $1 million. Part of you agreeing to give me the money is that you get a lien in the house so that if I don't pay you, you can take it. So if I don't pay you, if we follow the process, you as the lender can record a deed transferring title to my property. So you were never on title to the property as the lender. You didn't own it, but I gave you a right to take it if I didn't pay you. So it's involuntary because the deed is not signed by me. I am not voluntarily giving it to the bank. The bank is taking it because I gave them a claim. That's done through a deed of trust or a trust deed. It is not ownership. It's a lien right. Other types of involuntary liens are sheriff's liens. So if someone goes and gets a judgment against you, right? So car accident, you wreck $1 million Ferrari and they give $1 million judgment. This happens, right? They get $1 million judgment against you for this Ferrari that you wrecked. Well, they can go to the sheriff and get the sheriff to sell your house to pay the judgment, right? It's not quite as simple as that, but that's how it's done. It's a sheriff's deed. If you don't pay your property taxes, the tax assessor can sell your property and they would issue a tax deed. So depending upon what you do and how you do it, other people can actually control ownership of your property. It's involuntary. You didn't give it. It's rights that are created either by law or by contract.
Got it. So you mentioned to me off camera that there was two types of deeds that are the most common deeds and most commonly used in real estate. What are they and how do they work?
Right. So the primary voluntary deeds in California are what's called a grant deed or a quitclaim deed. So people often interchange those words and say, I want a quitclaim deed or I want a grant deed, not realizing that they really aren't the same. They both do the same thing from a perspective of they transfer title, right? So if I give a grant deed, I'm transferring title to a third party. If I give a quitclaim deed, I'm transferring title to a third party. But they have different rights and different guarantees. So on a grant deed, I am giving everything I own in that property now and in the future. So any future interest that I acquire, there's a concept in the law called after acquired title, which is way more complex than this conversation. But the baseline concept of I'm giving everything I now or in the future will own in that property, it means I'm giving everything. And it's like a guarantee, right? Whereas a quitclaim deed says whatever I have right at this minute is yours, but I could start acquiring an interest again tomorrow. So in California, the biggest thing with this is husbands and wives, right? So California is a community property state, which means once you're married, what you own, your spouse owns the vast majority of things. It's a community, right? And so the community is actually a quasi-legal entity under California law. So say I inherit a house from my mom. And inherited property is separate property. It's not community property. So my husband would not own that house that I inherited from my mom. However, if I start using my family income, which is community income, to pay for things relative to the house, now the house starts to become at least part of the community, right? And so I can have my husband sign off saying he is waiving any claim to the house. If he does it with a grant deed, he's waiving it forever, right? It is what he owns now and what he acquires in the future, so that community property interests don't attach. But if he gave a quitclaim deed, if he quitclaimed his interest to me on the property, it means whatever he owned at that moment he gave me, but he could start acquiring interest through that community property thing tomorrow, right? So there's a big difference, and it has huge impacts between a quitclaim deed and a grant deed. And you should be using the right one depending upon what you're trying to accomplish.
What would be the right ways to use the quitclaim deed?
So a quitclaim deed is often done with interfamily transfers or situations where maybe we're quitclaiming an easement, or there's a neighbor dispute and we're giving a deed to deal with the situation short term, knowing that it may need to be resolved or there may be issues later. Or maybe I am giving what I have now, but I know I'm getting more later, and I don't want to give up that claim. So again, an inheritance can be a situation where I'm giving up what I have now, but maybe I'm going to inherit part or more of the property later, and I want to make sure I'm keeping those claims and those rights to future. Also, we talked about a performance deed, right? It's a type of deed where it's conditional. I'm giving you title, but you have to do certain things, and if you don't, I can reclaim the property. So between a performance and a quitclaim, we may want to keep rights. So for example, this happens in like granting, it is common for property to be gifted to charitable organizations or to the government, with the understanding that it has to continue to be used for that purpose. And if they try to sell it, then it would revert back to the original owner, right? So we want to give it for charity. We want it to stay charitable. We don't want them to capitalize on it and make it a for-profit, things like that. So these are contracts. We can do pretty much what we want to do, but it's how we word them and what we use to make those legal things happen.
So they both transfer title. One of them just allows you to keep an interest in the property if you wanted to for the future, and one of them is never again will you have an interest. What if they get title back in the future? What if they add themselves on title on a grant deed? Would that still give them interest or again, or no?
They could not put themselves back on title, right? Because they've given their rights. But so say I give a property to my kid, and then the kid decides to give it back to me, right? So the deed from the kid to me is a new deed, and they're giving up all their interest. So now I'm entitled again. So This happens with spouses where, so for example, if we have a husband and wife where, say the husband doesn't have a good income or good credit, but the wife does, and the wife can qualify to buy the house. The lender will only want the wife on the loan and the wife on title. So the husband will release his claim to the property in order to do the acquisition, but then go back on title. And he goes back on because she has to give him, she puts him back on title, right? So a grant deed is permanent, but it can be overridden by another grant deed that changes title back to the person who gave it.
Got it. That makes sense. Now, I've heard of this. Like, we had a case recently where somebody, I think, got taken off title or took themselves off title, and all of a sudden that deed wasn't insured or something wasn't done properly, and now that person is claiming an interest on that property. Like, I don't know all the details, but have you ever had a situation like that? And can you explain to our public what likely happened?
So, what a deed is a deed is a deed, but title companies and insurance, right? Whether a title company will insure on a deed is a business decision that they're making as an underwriter. So if I sign over a deed and I just do it, right? So I'm a lawyer, right? I draft deeds. Most of the time when I'm drafting a deed as a lawyer, the people are not getting title insurance as part of that transaction. They've hired me because they want to give something to their kid or their parent, or they're selling it to their friend, and whatever
Yeah.
those situations are. Adding someone on, taking someone off, right? That is, attorneys are fully capable and able to do that, and rarely is title insurance part of that transaction. When a title company goes, when they go to sell later, right? Because that's what happens. This is when we find this stuff, right? When
Yeah.
they go to sell later, a title company will run a search. They do a search and they'll pull the deed record, right? And they'll see that deed that I prepared in the chain of title. Because there's no title insurance, they're leery about insuring on that deed. They're worried that there could be fraud, it could be fake, there could be undue influence, there could be different issues relative to that deed. So traditionally, when a deed is recorded that is not insured by a title company will request what's called an uninsured deed affidavit. And so the person who signed the deed is asked to sign an affidavit saying, yes, I signed this deed. Yes, I intentionally transferred my interest in this property. That makes the title company feel comfortable in their underwriting insurance decision that the deed wasn't fraudulent. And unfortunately, real estate fraud is just rampant. And whether it's wire fraud or title fraud, people impersonating owners of property, transferring title, or putting fake loans on properties is happening a lot. Now, when I say a lot, like, you know, most of us will never have it happen in our lifetime. It's not like that. But as in my job and what I do, I see multiple real estate frauds every month where someone has impersonated the owner of a property and tried to transfer their property out from under them. So the title companies, if there's title insurance on that, they're on the hook. They have to pay that claim for that title. So they're doing a higher level of vetting to determine that the deeds that are in the chain are real and that the people who signed them really are who they say they are. They have the authority, and that it still happens. We still have title fraud, but the affidavits are a way to mitigate. And so that's a common requirement. It is not a legal requirement. That deed is valid absent, under the law, there's a presumption that a recorded deed is valid, unless you prove it otherwise. So legally it's valid unless someone proves it's not. But um, title companies making an insurance decision. They're making an underwriting decision, not a legal decision. And they're not going to take the risk unless they feel comfortable that they're not taking an unreasonable risk. So an uninsured deed affidavit is a common request.
Got it. And that's very likely what happened in that situation. So, tip of advice, if you are doing any sort of deed, either A, get that affidavit, or B, make sure to get title insurance, because if not, if it ever comes time to selling the property, you could be dealing in one of those situations. Now, we're going to get into the other deeds like the performance deed, deed in lieu of foreclosure, transfer upon death deed. But I wanted to ask you, like, I heard somewhere like, oh, like on the news that people were getting properties transferred from underneath them, or people pretending to be somebody else. As a homeowner, let's say that happened to me. What are my options, just out of curiosity?
Yeah, it does happen, right? The most common situations where it happens are elderly people, right? Most of the time they have equity. Often they don't have a lien on their property, so there's equity in the property, and they're not monitoring their property as closely. Maybe it's a rental that they've let go, or maybe we put mom into a home, and so her house is sitting vacant, right? Those are often the situations that the bad guys will capitalize on to try and defraud those owners out of their properties. So you should be monitoring your title. There are companies that do it. Whether you hire a company or just the public records are available, you can check your title. It's something I recommend people do. You know, once a year, check and make sure no one's recorded something against your property. In my mother in the real world, she had a rental, and the rental was active. The property was fully occupied, but a bad guy pretended to be her and got a home equity line of credit against the house for improvements. The PACE loans, which are the loans that you
Yeah.
get from the government, they got a couple $100,000 PACE loan against her house, right, for all these improvements that weren't done. Right, there wasn't a roof done. All the PACE improvements are like energy efficient
Yeah.
improvements, and right, none of it was done, but they got a loan and a couple $100,000 that the lender had to eat, right? Because we were able to show that it wasn't my mother who signed the documents. The when you are in a situation where a fraud has happened, you want to notify the district attorney, the police, right away, because there's a criminal aspect to what's happening. And in some situations, the criminal system can get title to your property back. So if they can find the bad guy and they prosecute the bad guy, they can get that deed wiped out, right? So the fake deed no longer affects your title. If it doesn't get into the criminal system for some reason, then you're in civil court to get that deed wiped off your property. Because once a deed's on the title, like I said, it's presumed to be valid. So a court is going to be required to get it to be invalidated. So we're going to go to court and do what's called a quiet title action in order to get that deed taken off your property.
And in that case, where somebody puts a invalid deed or pretends to be somebody else, did they pre- fake a public notary on there? Or because most deeds require the signature of a notary, right? So what does that typically look like?
Deeds do require notarization,
Notary.
right? To be recorded, they have to be notarized. So there's multiple ways that fraud happens with notarization. One is bad notaries, right? There are bad people out there, so maybe you get a bad notary. Two is maybe they get an old seal from someone who's no longer working as a notary. So our notary seals, I'm a notary, right? They're good for, in California, 4 years. And that seal is what is really the initia of the notarization. So we're required, like when we stop being a notary, to destroy our seals. But maybe I didn't destroy my seal, or it got stolen out of my car, right? Like they can get a hold of a seal. Amazon was creating seals without certificates for a while. So
Wow.
to get a notary seal, you have to have a certificate from, in California. You have to have a certificate from the Secretary of State, and there's a whole process for getting a notary seal. But Amazon was making them for people who weren't notaries, and they got sued, and they stopped doing that. But there, so there were fake seals out there, or they will. They'll imitate a seal, they'll imitate a signature, they'll imitate a notary, and now with remote notarization, so you can do a notary online like we're doing this conversation, there could be a fraud there. But even that, IDs can also be stolen, so they can pretend to be, so it could be a real notary who did a real notarization, but the person came in with an ID, they believed it was who they said they were, and they convinced the notary that they were someone they weren't.
Or even
So
like a fake ID, basically.
Correct. A fake ID is common. I had a real case that I was an expert witness on where um, the husband and wife were estranged. And so the wife wanted to sell the house to get the money out of the house. And she had her cousin impersonate her husband. And she had his passport, right? So because it was at the house. So she had the husband's real passport. The cousin came to sign the document with her with the passport, and they looked close enough. The notary did not realize it wasn't really the person who was supposed to be, and that property was transferred out from under the husband. He found out when he made the mortgage payment the next month, and they sent it back because it had been paid off because she sold it and took all the equity and ran off.
Wow. Is that notary at liability if in that case?
So that notary was sued in that case, but the notary, in my opinion, I was an expert, followed all the procedures and did what they were supposed to do. A notary can, so just like you as a realtor or me as an attorney, we have a standard of care, right? We have a certain level of work that we're supposed to do. It doesn't guarantee we did it right, right? It's we've met the standard of what we're required to do. In that case, in my opinion, that notary met all the requirements. She did what she was supposed to
It was
do.
the ex-wife that basically committed fraud, basically.
Correct.
Yeah,
Correct.
got it. Okay, good. So let's get into the different types of Ds. That was good. I love that. Right?
So, but just the quick answers: monitor your title, and if something happens, notify the police and hire an attorney.
What, do you know the names off the top of your head of any companies that monitor your title?
There's one called Title Lock, kind
Title
of
Lock.
like LifeLock,
So it's
right?
almost like
Same.
monitoring your credit score almost. It's funny because my friend had his credit score, they pretended to be him, and then they
Yes.
started taking the mail from his mailbox. So he
Uh-huh.
didn't even know that he had bills coming in because they would go by
Right.
every day, check the mail for those bills. And then when he found out his credit had dropped like so much points, and then he
Right.
got the Experian credit monitoring thing. So I'm imagining that the
Yes.
title thing is very similar to that, where it would notify you if somebody switches or tries to switch title right away, which
Yeah.
would make it easier.
It's helpful, but it doesn't solve the problem, right?
Yeah.
Because it doesn't. They notify you when someone's recorded a fake deed against your property. Well, it's recorded. It's too late, right? Like you still have to deal with getting that lien off the title, but the sooner you know, the better,
The
right?
better.
So
Yeah.
it's definitely better than nothing. Monitoring your title one way or another is better than nothing, but there's no way to fully avoid this.
Wow. That's crazy.
Yeah.
Okay. So in a performance deed, under what circumstances would I use a performance deed? Can it be used on a subject to transaction? And how would that protect
It
the
could.
seller?
It's often done in family situations, right? So, say grandma leaves the house to Johnny, the grandson, but only if he finishes college, right?
Mm,
So, grandma wants to control Johnny's college, and so she conditions, right? Puts a
wow.
performance obligation on that, and if he doesn't do it, then it can get transferred to someone else, right? So that's what those are designed for. You're gonna have to satisfy some condition, or if you breach it, it'll allow for some version of rescission or reversion to someone else.
If I were to use it in a subject to transaction, let's say somebody takes over my mortgage and I
Mm-hmm.
use a performance deed saying, hey, look, like, yes, I'm transferring title to your name, but if you miss more than 3 payments, I want the title transferred back to my name and I'm taking ownership. Is that legal? Illegal? Can
It
it be
is.
enforced? Can it not be enforced?
It isn't illegal, right? But it enforcement would require you going to court unless they voluntarily sign the deed. This goes back to the voluntary or involuntary. The performance deed says if these things happen, I'm entitled to make a claim, but it doesn't create a deed in and of itself. So again, the court would have to say this obligation was there, it was breached, and so this result happens, right? So it's not an automatic foreclosures like that too. For if you've lent money and there's a deed of trust in California, that's the document we use. It doesn't just happen. If you stop making payments, you still have to follow a process and do certain things before the foreclosure can happen. In deeds of trust, if I'm renting the property, there'll be a what's called assignment of rents, right? So that's a common document in a
Commercial.
loan, in a right, in a commercial transaction, assignment of rents. It says if I stop making the payments, the lender can go collect the rents, because it's not fair for me to collect the rent and then not pay the
Yeah.
lender. But an assignment of rents isn't enforceable in and of itself. You still have to go to court and get the court to enforce the assignment of rents before the tenants are obligated to pay to the lender, not to the landlord, right? So that you can contractually agree to these things, but enforcement, depending upon how it's done, is going to require court in many cases if there's not voluntary agreement.
So on a performance deed and a subject to type of transaction, what you're saying is that even if I put a 90 days of missed payments, and even if we sign like an affidavit title, I can't just take that to and get title transferred to me?
No, because again, a deed would have to record to change title, and you don't have a lien that would allow you to do that yourself. The other person would have to give it back to you, or a court would have to order it back to you.
And a pre-signed deed wouldn't work because it's pre-signed basically.
Pre-signed deeds are not legal in California. The idea with a deed is that it is a present transfer until we start talking about a transfer on death deed. But the idea is that a deed is a present transfer. So you have to have the intent to transfer at the time you sign the deed for it to be valid. But one of the things that does happen is that we can put a deed in escrow. And so you would sign it in escrow, and certain conditions would have to happen so that the escrow would be authorized to record it if certain things happened. But that's done through this neutral third party in escrow, where there's conditions and contracts and all of that. So a deed in escrow that's pre-signed could be done, whereas directly it doesn't work. It's not valid. It goes to the concept in the law of delivery.
So basically, in other ways, if I were to do a subject to transaction and there was a performance deed, the way to do it would be to put the deed potentially in escrow, and that would make it like somewhat enforceable, where escrow can record the deed. Can it be like a servicer? Can I give it to a servicer and the servicer say if they don't make three payments, then that can get transferred back to me, or does it have to be
Potentially,
escrow?
you would have to look at the contract and what the rights
The
and
contract says
responsibilities are. Again, every situation is
it's
specific and
different.
unique, but a deposit with a third party where certain conditions are met is probably going to work. The problem is California is very favorable to consumers,
Yeah.
and so anything like that, they're going to presume it's overreaching and unfair. So you're going to have to overcome those burdens if they try to fight, even if you record your deed, right? So say I had this deed in escrow and we record it. If they file a lawsuit and claim that it was unfair, or they didn't intend it, or they didn't understand, right? All the things that people claim, a court could side with them. So we want to mitigate and manage all that as much as possible to avoid a further complaint, a further lawsuit, a further dispute.
Got it. So let's talk about the transfer upon death deed, which,
Correct.
to be honest, like I had heard about that, but when you brought it up, I'm like, oh yeah, that's a thing. So how does that work?
So this is designed to avoid the need to set up a trust to transfer your stuff when you die. So people don't think about it, but when you sign a deed, right, one of the things that's on the deed is what's called a vesting. And your vesting says, I'm a married woman, I'm a married man, I'm unmarried, I'm divorced, I'm widowed. Why do we put that on there? It's giving people a sense of who our heirs are, who are the people that our stuff would go to if we die. So if my husband and I are on title as husband and wife as joint tenants, that joint tenancy creates an automatic transfer right to him upon my death. So if I die, my husband gets the property automatically. So all of those things, all of those factors go into that decision making on what a deed does. So vesting is succession planning. People don't realize it, but that's the whole point.
Yeah.
So a transfer upon death deed is another way of vesting, of succession planning. It says, I'm the owner of this property, and when I die, whoever I list on the deed is going to get title. They don't get it right now, right? So it is not a present transfer. So say I want to give my house to my daughter when I die. a lot of people will put the daughter, their idea is, oh, I'll put her on title and as joint tenants so that if I die, she'll automatically get the property. Well, the problem with that is as soon as she's on title, any creditor or lien or judgment against her is now can attach to your house, even though she didn't pay any money towards it. So again, she wrecks $1 million Ferrari and they get a judgment against her for that $1 million. They could take your house, even though she contributed nothing to it. So we don't want to do a present transfer and put people on title who shouldn't be on title. But in order to avoid probate, which is what this is all about, because probate is the government deciding what happens with your stuff at a very high price, the transfer upon death deed says, when I die, my daughter gets my property. And so she'll get it without probate, but not until I die.
Got it. Not only that, but with if you transfer it during your lifetime versus waiting to transfer it afterwards, it gets rid of the step up in basis, right? So now
Does.
there's potential tax consequences if she ever wants to sell the property. So I
Yes.
see this all the time where people add people on, remove people on title. It's so risky,
Yeah.
and it's like, man, like yeah. But
So there's two different tax issues. One is capital gains, right? So you talked about step up in basis. So when I die, the basis in my property goes to present value. That's one of the gifts of death. Death takes you up to present value. So if I bought a house for $200,000 20 years ago and I die and it's worth $1 million, my daughter's tax basis is $1 million. She doesn't have to pay capital gains on that whole 800,000. But if I transfer it during my lifetime, there's capital gains on that 800,000. Someone's paying those taxes. And not only is it capital gains, which is income taxes, there's property taxes. So used to be in California that a transfer to a child could be exempt from property taxes, but it's not now. So as soon as I add my daughter on title, guess what? My property tax bill is going to go up versus my $200,000 base property tax
yeah,
bill. I'm going to have a 600,000 base property tax bill because I gave her half, right? So her half's going to get reassessed to market value. So property taxes, income taxes, there's a ton of
tax
impacts of this.
consequences. What is a deed in lieu of foreclosure?
So if you have borrowed money and you can't pay it back against your house, right? So it's specifically related to a mortgage or a deed of trust, as we call them in California. So I borrowed and I can't pay it back. Maybe I lost my job or my spouse died and I can't afford the payments anymore. If I don't make the payments, the lender is going to follow a process to foreclose, right? And it's in California, it takes 9 months to a year for a lender to foreclose. And it's a really unpleasant process, right? They're sending you notices. They're calling you. You're under stress. People start calling you, asking you if you want to sell your house. And, it's a
Yeah,
really stressful, emotional thing, right? And you're struggling with your financial crisis. And then all this other chaos is going on. So people do it without talking to the lender. I do not recommend that. But if you can't do it and you're not going to be able to recover, you can reach out to the lender and tell them, I am not going to be able to make this whole. And so I would like to give you back the property. And some lenders will agree and allow you to deed the property to them. So if you do that, you're voluntarily giving up your right versus them foreclosing and taking it from you. It'll mitigate all that emotional drama and all the phone calls and the anxiety. And often you can negotiate time to stay in the property, when you're going to vacate. You can negotiate how they impact your credit. You can negotiate any repayment issues. There's there's tax consequences to getting foreclosed upon. So say I have a $1 million mortgage and I can't pay it, and the lender only sells the house for $800,000. That $200,000 difference is taxable. So not only am I broke, but now I have to pay taxes on $200,000 of debt forgiveness, right? So again, there's ways to try and mitigate and manage that through working with the lender if you're not going to be able to make the payments.
and if you do a deed in lieu of foreclosure, can you negotiate so that you don't get that tax consequence? Like, hey, look, instead of you going through the foreclosure process, I'll deed the property back to you, but I don't want this tax consequence?
The lender, it just doesn't control the tax implications. That's the government. That's not within their scope. But mitigating and managing, there are ways to do that.
So what would be an example of it?
So the working with the lender on how and what they were able to do in order to manage the debt forgiveness and how that's worked out. So there are ways you can do that, whether it's, putting a payment plan together to manage the debt that would have been forgiven, or negotiating with the lender to try and mitigate that. That's going to be something that you're going to want an attorney if you're trying to do that, to negotiate and manage.
Got it. Okay, good. General warranty deed, special warranty deed.
Mm-hmm. So warranty deeds are used in other states, but really not in California. Our grant deed provides comparable level of guarantee, which a warranty is a guarantee, right? The idea of a warranty deed is that you're guaranteeing title. In California, we don't do that because we use a grant deed, which has similar properties, and we use title insurance in most of our transactions. So the title insurance mitigates the need and the process for warranty. So you'll hear about them, you'll see them, but that is not a deed that's used
In
in
California.
California.
What about a special purpose deed?
Yeah, so a special purpose deed would be a deed done for a specific thing. So some of the examples, like I talked about, were giving something to a charity, right? Where I'm granting this property for the purpose of building a sanctuary for birds or a sanctuary for turtles, right? Like whatever it is that you care about and want the property to be used for, that special purpose would be what we're talking about. And it would be kind of like a performance deed where you get this, but with these limitations.
Got it. Gift deed.
So when you're giving away stuff, right? So say I want to give a gift of a property to my kid, a gift deed is what you would use to do that. And the idea is that there's no consideration because on a deed in California, we're taxed when we deed a property. Not only do we get property tax, but actually recording the deed is taxable. So if I sell a property for $1 million in Ventura County, I'm going to pay $1,100. It's $1.10 per thousand in transfer tax. In addition to then getting reassessed at a new tax amount. So on a gift deed, there's no transfer tax because they're not paying for the deed. However, it does not avoid reassessment. So if I owned a property, like I said, I bought it for $200,000 and I'm being taxed based upon that dollar amount because of Prop 13 in California, and it's worth $1 million when I give it to my kid is going to get reassessed to property taxes based on $1 million valuation versus a $200,000 valuation. And so a gift deed will avoid transfer tax, and it tells the assessor why the deed is happening, but it will not avoid property tax reassessment. There might be ways to mitigate that, but that's a different discussion. And there's forms that are required whenever you're trying to mitigate property tax reassessment in a transfer situation.
Got it. What about like if I'm doing estate planning? Like let's say I don't know what the limit amount for inheritance tax is. I think it's like 11 million per person, 12 million per person, somewhere in that ballpark.
It's in that range today,
Yeah. But it
but
could change
it
in the
moves
future,
around
right?
a lot.
Right. So like let's say that it moves down, right? And let's say for
Right.
somebody like me who has a decent amount of properties, if I gift the property to my son during my lifetime, do I have to pay taxes on that gift while I'm gifting it to my son to kind of avoid the inheritance tax, or what? How does that?
There's a whole bunch of different strategies that people employ to try and mitigate and manage this, and it really depends on the size of your estate. Because there are ways to get like when they're spouses, it can cause problems. But if you set up the trust right and you set up the distributions right, you can mitigate and manage and give yourself a little bit more space. But this is really you've got to talk to a planner, and
Estate
your
planning.
every specific situation is different. That so you can during your lifetime every year you can gift a certain amount to anybody you want, right? So a lot of times parents will just start gifting 10, 20 grand to their kid and their spouse every year because they can do that every year and it's tax free, right? So it's a way to try and weed off and because they're going to get it anyways, right? If
Yeah.
the parents really are at a point where they don't need it, they can start gifting it and avoiding it. There's a certain amount per person per year. But you got to be careful because you can gift it to like an adult, but if you gift it to a child, then you can screw up the child's taxes and create a taxable, right?
Yeah.
Again, anything that you're doing when you're worried about taxes, your CPA or an attorney should be consulted because what the internet says and what's true are not always the same thing.
That's funny. Bargain sale deed.
Yeah. So again, that's a deed used in other states, and it is designed when we're not doing title insurance and not managing the traditional things that we do here in California. So you would not see a bargain and sale deed here.
And sheriff's deed and tax deed.
Right. So again, sheriff's deeds and tax deeds are deeds that are involuntary, right? And they're the result. If you don't pay your property taxes, tax assessor will actually sell your property. You're entitled to so say I owe $50,000 in property taxes, but my house is worth $1 million. Government doesn't keep the difference. They get what they're owed, and then any lien holders would get what they're owed. But if there's money left over, you do get it back. It's not a total fail, but it's expensive, and you've lost your house, right? A sheriff's deed is when there's been a judgment. So someone's gone to court, got a judgment against you, attached it to your property, and then is able to get your property sold. So the sheriff literally on the courthouse steps sells your property.
And is it literally like a sheriff?
It is. It's the sheriff's. Yes.
Cool. Awesome. Any other things that we might have missed as it relates to different types of deeds in real estate?
Well, real estate is full of interesting challenges and obstacles, and every time you think you know something else happens. But I would say, and this is not about me, it's about your protection and safety. When you're dealing with title, an attorney really should be consulted. There are so many pitfalls of taxes or judgments and things that can affect your title. I mean, I had a real world situation where parents deeded to their children who were children. They were not adults. Again, the intention was good, right? They wanted to have it in case something happened, the kids would get the property. Well, minors, right, under the age of majority are not allowed. They can get property. You can give a property to a minor, but a minor can't transfer a property. So then they needed to sell the property. Well, we had to go into court and get a conservator appointed for the kids in order to sell the property because that's what's required to sell. So good intentions, but they spent a ton of money getting control of their property back because they put it in the name of a minor child.
Wow.
So you really, no bad intention, right? But you really need to understand. And another thing that happened was during the foreclosure crisis, 07, 08, some bad crooks of fraud, mortgage rescue people would have people put other people on title to their property with the idea that it would stop the foreclosure. And sometimes it did, not always. Technically they could still foreclose. Some lenders would, some wouldn't. But so say I was in foreclosure in 07, 08, I've worked through it. I'm back. I have my house, but I put these people on title. Now I got to get them off. And I don't know who they are. They may not even be real people. So we're having to go to court and I'm dealing with some of these now where 15 years later, these bogus people are on title and we got to get them off so that people can sell or refinance or manage their own property. So it is not to be taken lightly, deeding your property.
I agree. Now, if somebody saw value in this and they wanted to get in contact with your law firm, how would they go about doing that?
Yeah, the easiest way is our website. It's www.relawapc.com. And I'm on social media, YouTube, Facebook, LinkedIn, all at Jennifer Felten Esquire.
I love it. I love it. Jennifer, I wanted to say thank you for taking the time to be on the show. I always enjoy picking your brain for free on this. So I always, whenever I get the opportunity, I'm like, okay, let me ask this, let me ask that. So I
Yep.
appreciate it. So for our viewers, if you've enjoyed this episode, make sure to hit that subscribe button. If you feel that this episode will be helpful to somebody, make sure to hit the share button. Today we had Jennifer Felten with Relaw. We talked about what are the different types of deeds in real estate and how do they work. Talked about a quick claim deed, grant deed, deed of trust, grant deed. Yeah, so we talked about all of them. So make it a great day, and thank you, Jennifer. Bye bye.